good afternoon. Today we are dealing with quite a sensitive topic of deceased estate administration. What do you do when your loved one passes away and they leave behind assets such as house, vehicles, and finances in the bank? A lot of us don't know what to do in such instances, and I am here to assist today with just a summary. Before we go further, let me put a disclaimer. This here is not legal advice extensively, so should you need assistance, I urge you to approach attorneys such as CTA. Their details are above. Yes, what do you do when you hear of passing of a loved one and they are leaving behind assets? Firstly, you need to make haste, meaning you need to, within 14 days of death, you need to notify the Master of the High Court about the death. What does that mean? It means you need to submit certain documentation to the Master of the High Court, and it's not an easy process. It's quite complex, but anyone who's nominated by the family through an affidavit, next of kin, be it the spouse or the children of the deceased, can approach the Master of the High Court with a number of documents to notify the Master of the death. As I mentioned, this must be done within 14 days. The documents that you need to carry with you is the original ID of the deceased, the original death certificate, your ID as the person reporting, that affidavit that is drawn by a family member nominating you to represent the family, and you need to complete what is called J29 form, which is a death notice form that you will find at the Master's Court. What is the purpose of this notice? The purpose of the notice is that the deceased estate starts to be administered. The estate of the deceased is generally dealt with under the Administration of Estates Act, the Insolvency Act, the Recognition of Customary Act if the person was married in terms of that, and the Wills Act, which will deal with whether the will was valid, if it's applicable or if it's available. The Master then looks at the summary of the entry of the assets that you could find at the time. So you have to have a list of the assets that the deceased had in place at the point of their death, meaning you have to make a list. They had vehicle, BMW, whatever. They had 2 properties, one where one was based where. They had F&B account, a Standard Bank. I'm just giving an example of what you would make as a list, a general list, because the proper compilation of the list will be done by an executor. Talking about an executor, let us deal with the difference between a letter of authority and a letter of executorship. When you approach the Master of the High Court notifying them of the death, they look at the value of the deceased's assets. If the value is below 250,000 rands, then the Master will issue what is known as the letter of authority. This letter of authority is generally issued to who? To the person that was nominated in that affidavit that we spoke to, or to the person that is accompanying them, be it a spouse, be it children, as we spoke. If the estate is above 250,000 rands, then a letter of executorship will be issued. Generally, this letter is issued to the surviving spouse or to somebody who has more knowledge, like an attorney assisting a surviving spouse, because there is complexity with estates that's of a higher value. What does the executor do? Be aware that at the point where the person passes on, their accounts are being frozen, meaning you may not be able to access any monies that they would have used in their accounts. So the executor has to work very quickly to notify all the creditors about the death, and to open what is known as the late estate account. This is a bank account wherein all the other monies that the deceased had will be now transferred into this account. It's going to be used, this account, to deal with the account of the deceased estate. Then the executor prepares what is called a liquidation and distribution account. It is quite a complex one, which, like I said, you would most likely need assistance of an attorney. This account shows, it indicates the assets, the liabilities, the debts, the heirs, the legatees, meaning people who are supposed to be heirs or who are supposed to inherit from the estate of the deceased. This account must be completed within 6 months of the appointment of the executor. If they fail to do that, they will have to apply for condonation. It's another long process. Then the L&D account shows the distribution of the assets. It must be approved then by the Master of the High Court. Once the L&D account is approved, then it is open for inspection by the other creditors who may have missed it, who may have not been aware that, listen, the deceased has passed on and therefore you are supposed to claim. It is open in terms of Section 35 of the Administration of Estate Act. Then the executor must finalize this L&D account within 12 months. To finalize this, it means that they must pay what needs to be paid in terms of the L&D. They must sell whatever assets that needs to be sold. They must distribute to the heirs or the beneficiary of the deceased. Sometimes distribution means that there must be transfer of property from the deceased name into the name of the new owner, being the heir or the beneficiary, and that may take quite a while. So as I mentioned, it is quite a complex process, so you will definitely need an attorney. I hope this summary helps. For any further assistance, please